Greetings, friends, on behalf of the 18 denominations that make up the North Carolina Council of Churches. I'm Jennifer Copeland. Welcome back to day 2 of our critical issues seminar, The Ties That Bind Democracy. Yesterday, we heard from former Charlotte Mayor Jennifer Roberts and former State Supreme Court Justice Bob Orr, who are co-conveners on behalf of the Carter Center. They focus their work on maintaining confidence in the integrity of our elections and ensuring the safety of those who exercise their right to vote. That session is uploaded to our YouTube channel, or soon will be, for those of you who may have missed it. But today we're going to hear from Hillary Harris Klein about why redistricting matters. Hillary is an attorney for the Southern Coalition for Social Justice, one of the organizations that holds our lawmakers accountable when access to the polls is suppressed or voting districts become less than competitive. And I will let Hillary fill you in on the very important work she does. But first, let me tell you some things about Hillary. She is on staff at SCSG as the Senior Counsel for Voting Rights. But before she began this important work, she spent time as an attorney working on behalf of prisoners' rights, an issue important to the council as we continue to strive with all of you for criminal justice reform. She has also worked on anti-human trafficking matters, another issue important to the council, especially as it relates to our advocacy for immigrants and refugees. She has clerked for the Honorable Catherine Eagles for the U.S. District Court for the Middle District of North Carolina. And you may know that the Honorable Eagles was the first woman to serve in the Middle District. And as if that weren't enough, Hillary served in the Peace Corps in Tanzania between college and law school. Hillary, one of my daughter's closest friends from high school, is from Tanzania. It is indeed a small world. We are glad to have you here with us today to discuss the very important work of the Southern Coalition for Social Justice, and especially your crucial role to ensure that North Carolina has fair, competitive voting districts. Friends, I give you Hillary Harris Klein.
Well, thank you so much, Reverend Dr. Copeland, and thank you to the North Carolina Council of Churches for having me and allowing me to speak. And thank you for everybody who showed up today. I'm going to present for maybe 30-35 minutes, but then I'll be happy to take any questions and answer any thoughts that you have that you want to share with the group as well about what we're talking about. I'm going to go ahead and share my screen and just give me a shout if you can't see it after I do that. So I've been asked to speak today about why redistricting matters. And I'm also going to go into what recently happened this cycle in 2021-2022 with redistricting litigation, where SCSJ was lead counsel for one of the plaintiffs groups. So I'll be doing a little storytelling too about recent events in redistricting. But to kick us off, the Southern Coalition for Social Justice is a 501c3 nonprofit. We were founded in August 2007, right here in North Carolina. We were founded by Anita Earls, as I think was mentioned, who is now an Associate Justice on North Carolina's Supreme Court. And we partner with communities of color, socially disadvantaged communities, to help them advocate for their rights. We are a team of lawyers, we are social scientists, community organizers, media and communication specialists, and we provide those resources to partner with these groups beyond just representing them in litigation. We also do a lot of advocacy efforts here and throughout the South to help dismantle structural racism and oppression. Redistricting. What is redistricting? I think is important to understand before you talk about why it matters. To determine how we will be represented in federal, state, and local governments, we redistrict the lines that decide where a representative is going to be elected from and where the constituents that that representative is going to represent in the body. This happens at the federal, state, and local government. So federally, if you just voted in the primaries, you probably voted in the primary for House of Representatives at the federal level. On the state level, we have a state Senate and a state House of Representatives. Both of those offices are districted. All of those elected officials represent specific districts in North Carolina. And then at the local level, we have commissioners for each county, and often they are districted. Sometimes they are at large, and sometimes in some North Carolina counties, they're hybrid systems where some are elected at countywide and some are elected by districts. So redistricting happens at all of these levels: federal government, state government, and local. And because it happens at all levels and affects representation at all levels, it impacts how we fund schools, hospitals. It affects how essential services are distributed, especially at the county and the municipal levels. And so to ensure that these districts represent communities, to ensure that they are equal, for reasons I'll talk about in a little bit, we redraw the lines at each of these levels after every federal census. And as you might remember, there was just a 2020 federal census that just occurred. So all of the redrawing of lines at federal, state, and local level just occurred, or in some counties is still, and municipalities is still occurring in North Carolina. Now a word that we'll be talking about: gerrymandering. Gerrymandering is when lines for these districts are drawn in order to predetermine the results. So in other words, instead of getting elected by swaying hearts and minds and being held accountable to their constituents, lawmakers or other map drawers can use mathematical modeling in order to predetermine the results of an election. Now, they can do this using partisan data to predetermine the partisan results, but they can also do it using demographic and racial data to predetermine which ethnic, racial, or even language group is able to elect their candidate of choice. On the slide here, you see two examples of how gerrymandering works. On the left, you can see cracking. This means that you take a community of maybe one partisan affiliation or one racial group, and you split them amongst different districts. So here we have a community of the tan circles being split amongst 4 different districts. Another type of gerrymandering that happens is packing. And this is where you pack all of the group artificially into one. And when I say artificially, I mean you don't respect geographic boundaries, you do not respect natural community boundaries, but you artificially pack communities together. And here you can see the tan circles are now, most of them are put within one of the 4 districts. And for the remaining districts are all majority of the white circles. So those are 2 of the strategies that are used in order to effectuate gerrymandering. Now, who draws? Who does this? Who draws these maps? On the local level, town or city councils, boards of county commissioners, and boards of education generally draw their own districts. In North Carolina, there is a possibility for the General Assembly to go in and draw local districts as well, as happens from time to time. On the state and congressional level, the North Carolina General Assembly is primarily responsible for drawing these lines. But as I will talk about later, sometimes the courts have to step in and put in their own court-drawn remedial districts when what the North Carolina General Assembly draws does not follow the law. So what is the law? There are federal protections in place. One of the most important protections is the Voting Rights Act, passed in 1965. It was designed to prevent systematic and widespread voter discrimination that was occurring at the time. As part of that, the Voting Rights Act protects the creation of majority-minority districts, where there are populations of minority voters that are compact, that could be a majority in a single-member district. The Voting Rights Act, in certain circumstances, requires that district be retained and be drawn every time you redistrict. There is also the federal judiciary, and the Supreme Court specifically, has also held that districts have to comport with a one-person, one-vote standard. This requires that districts each have more or less equal number of residents and population in order to ensure that one person's vote in one district has substantially equal power as one person's vote in another district. If those numbers are imbalanced, if there's half the number of people in one district compared to another, that smaller district, the people technically have double the voting power, and that's just not fair. So the Supreme Court has held that districts at all of these levels have to comply with one person, one vote requirements. Those requirements vary according to what kind of district we're talking about. So local districts at the county level, at the city level, have to be within a 10% deviation of each other. State districts here in North Carolina have to be plus or minus 5%. And then when you get to congressional districts, they have to be nearly equal as practicable. And commonly they are within 1 or 2 people of each other. So they have to be nearly equal. There are also state constitutional requirements in North Carolina. We have a free elections clause that states all elections shall be free. This clause does not exist in the federal constitution. It's unique to North Carolina. There are other states with similar clauses. We also have an equal protection clause that states no person shall be denied the equal protection of the laws. This is very similar to the federal equal protection clause under the 14th Amendment, but it is interpreted in North Carolina's equal protection clause is interpreted much more broadly than the federal protection. It provides more protection of voters than would the federal constitutions. And we also have freedom of assembly and freedom of speech clauses that protect against any kind of retaliation for speech. And I'm sure for members of the North Carolina Council of Churches, these are also very important clauses that are part of the North Carolina Constitution. So let's talk about redistricting in North Carolina. If you have lived here for a number of years, you probably have seen across the news that there is a lot of litigation in North Carolina having to do with redistricting. And that is something that has been occurring in North Carolina for decades. One of the most important Voting Rights Act cases, Thornburg v. Jingles, comes right out of North Carolina. Plaintiffs in that case challenged multi-member districts in state legislative offices. They were being elected in multi-member districts, and that was found to be a violation of the Voting Rights Act because it diluted the voting power of minority voters. I'm going to talk a little bit about what happened last redistricting cycle because I think it's really important to setting the stage for what happened following the 2020 census in this redistricting cycle. But in the last cycle, these are just a few of the many litigations that were filed to challenge the maps, and the lines were redrawn several times for the congressional and the state house districts. So if you voted in the 2010s, you probably voted in under several different maps for Congress, several different maps for state house and state senate. But a few of the really important decisions include Covington v. North Carolina. This was a case in which SCSJ served as lead counsel. In this litigation, the Supreme Court summarily affirmed a lower court's decision to strike down 28 state house and senate districts because they were racial gerrymanders. The legislature had used race as its predominant factor in drawing those districts. It had done so in a way that had the effect of limiting and reducing the number of opportunity districts for voters of color. Essentially, it packed voters of color in mostly in metropolitan areas. It packed voters of color together and overall reduced representation for those voters. Another case, Cooper v. Harris, struck down congressional districts 1 and 12 as racial gerrymanders. The case Common Cause v. Rucho, also before the US Supreme Court. In that matter, the Supreme Court held that partisan gerrymandering is non-justiciable in federal courts. In other words, federal courts will not hear any challenges about partisan gerrymandering following the Common Cause v. Rucho decision. And finally, Common Cause v. Lewis, which was one of the last redistricting decisions from last cycle. This is a lower court state court case in which 21 state Senate and 55 state House districts were struck down as extreme partisan gerrymanders. That was a trial court decision, and that decision was not appealed to the higher courts. So this was a bit of the legal landscape applicable in North Carolina coming into the redistricting cycle following the 2020 census. So let's talk about the 2021 redistricting cycle. And I'll start with talking a little bit about the process. So you might remember that the census, the 2020 census was delayed. And this was because of the COVID pandemic, which both disrupted the Census Bureau's ability to process the data and collect the data, but also people's ability to respond to the census. So the release of census data, which generally we would have expected to happen in the spring of 2021, it wasn't released until late summer. The North Carolina General Assembly chose to wait until the census data had been released, or the eve of the census data's release, in order to start the redistricting process. In other states, they had the option of preparing for the redistricting process, taking public comment on the current maps, on what people wanted the maps to look like, on the what are called redistricting criteria. They chose not to do that until the eve of the census data's release in August. The General Assembly also decided to do no analysis of racial data to ensure they would protect against vote dilution. So I spoke earlier about Section 2 of the Voting Rights Act. That's been incorporated by reference into our state constitution under the supremacy clauses. And courts had held in the past, you have to look at the data, you have to do some analysis to protect and assess what kind of districts might be required to prevent vote dilution. The General Assembly had done this in previous redistricting cycles, but this redistricting cycle, they decided not to do that at all. And in fact, the General Assembly and leadership decided to prohibit the formal use of racial or partisan data at any point in the redistricting cycle, from the drawing phase to the voting on districts phase. They prohibited any formal use or presentation of racial or partisan data. They did this because they were purporting to have a transparent process in which racial and partisan data would not be used, and those considerations would not be part of the process. But as we learned later in litigation, leadership in the General Assembly was actually using undisclosed partisan assistants to help them draw the maps. They never instructed those assistants against using racial or partisan data in advising them. And they also, at least for the House map, we learned in litigation that leadership used secret and since destroyed concept maps. These maps were never saw the light of day. We have no idea what they look like, but we know that they were used. They were prepared by partisan assistants and used to help leadership draw the maps that came out of the 2021 redistricting process. The enacted maps were very easily identifiable as extreme partisan gerrymanders, and I've included an example from Guilford County. Here, this is the congressional districts in Guilford, and you can see Guilford is split 3 ways into 3 separate congressional districts. Why does that matter? What is that an example of? We go back a few slides. I mentioned cracking. Well, this is an example of cracking. And essentially, what this means is that Guilford County the residents of Guilford County had no representation before Congress under this map that would be responsive to the needs of that community as a whole. In each of these districts, the populations of Guilford County would have been very much outnumbered by the predominantly rural parts of the remaining parts of these congressional districts. And that means that each of the representatives from these congressional districts don't necessarily have to be responsive to what people in Guilford County or specifically Greensboro would have wanted in their government. They could be non-responsive to that and still be assured to be reelected the next election cycle. We also saw in the maps that were passed the destruction of districts electing candidates of choice for voters of color. And that was a very foreseeable result of the General Assembly leadership's decision not to do any kind of racial analysis to prevent vote dilution, but also to prevent the formal use of race data in assessing the impact of maps before they were voted on. Both of these results were easily apparent to a lot of people looking at the maps, and these patterns followed all three of the maps: the congressional map, the state Senate map, and the state House map. So of course, lawsuits were filed. SCSJ represented Plaintiff Common Cause. There were two other plaintiffs groups as well that sued in November and December of 2021. We did about a year's worth of litigating in just a few weeks and held a trial in early January of 2022. It was a week-long trial with experts and witness testimony, and some of the legislatures even testified. And then by January 11th, the trial court had issued its order. The January 11th, 2022 judgment found that all three maps were the result of intentional pro-Republican partisan redistricting, which I think is important because if you remember, the legislature had purported to say it would be a process free of partisan data and free of racial data, but the findings of the trial court following this trial were that this was an intentional partisan gerrymander. The expert analysis also showed that these maps were non-responsible and durable to the will of the voters. What do I mean by non-responsive? I mean that if there were drastic percentage point changes in how statewide the electorate voted, preferring one party over the other, the maps and the results of the maps and who they elected would stay the same. In other words, if the electorate were swayed by a policy platform, by the actions of its representatives, that would not translate into a different electoral result under these maps. The panel recognized, the trial court recognized that these results are incompatible with democratic principles. Maps that people vote under need to be responsive. They need to be reflective of the will of the voter and not a predetermined result. But despite all these findings, the trial court held that partisan gerrymandering claims present a political issue beyond our reach. They essentially held the same thing that the Supreme Court held in Common Cause v. Rucho, that partisan gerrymanderings are not justiciable. And that decision was under the state constitution, not the federal constitution. And as I mentioned before, the state constitution has this slew of protections that are more broad than the federal constitution. This decision was appealed to the North Carolina Supreme Court, which in a 4-3 order followed by a full opinion, reversed that legal finding and held, we hold that our Constitution's Declaration of Rights guarantees the equal power of each person's voice in our government through voting in elections that matter. For an election to be free and the will of the people to be ascertained, each voter must have substantially equal voting power, and the state may not diminish or dilute that voting power on a partisan basis. The Supreme Court's reversal struck down all three maps and then sent the matter back to the trial court to facilitate either the approval of new General Assembly remedial maps or for the court to fashion its own maps if the General Assembly failed to make remedial maps that satisfied the constitutional standards that were described by the Supreme Court. A second holding that was very important came out of a claim that was unique to plaintiff common cause. And this goes to the General Assembly's failure to do any kind of analysis of racial data to prevent vote dilution. The court held that in order to comply with North Carolina's Constitution, the Constitution requires the General Assembly to conduct racially polarized voting analysis each redistricting cycle after each census in order to assess what districts might be needed in order to prevent minority voting strength. So the matter was sent back to the trial court. The General Assembly engaged in remedial redistricting earlier this year in 2022. They passed on bipartisan lines, they passed a state house map, and that map was approved by the trial court. They passed a Senate map that was not bipartisan. It was also approved by the trial court. And the General Assembly also enacted a new congressional map, but this was actually rejected by the trial court. And instead, the trial court employed the use of special masters. These are nonpartisan. They were former judges assisted by political scientists that crafted an interim congressional map that basically altered the remedial map that the General Assembly had put in place, but it altered it to the extent required by the North Carolina Constitution. And at the bottom of this slide, I've put the website for the General Assembly's redistricting website, where if you want to take a look at these maps and see some more of the legislative record, it's all posted for you to view if you would like to. So looking ahead, what's going to happen next? Well, the primaries just happened. The 2022 general election will occur under each of those remedial maps that I described. The congressional map may or may not change, but there will have to be some sort of new enactment of a congressional map after 2022 because the court's map was only for this general election. Of course, it's fully within the General Assembly's power to just enact the same map that is already in place. But whether that's going to occur or a new map is going to be crafted is to be determined. There are also ongoing appeals. So the defendants have appealed to the United States Supreme Court, advocating for what's called the independent state legislatures theory. This is a theory that for federal elections and the congressional map, that the state legislature, the General Assembly, can make decisions and enact laws that are not reviewable by the state courts. And this theory would basically give state legislatures impunity when it comes to congressional elections, laws, redistricting, whatever might fall within the purview of a general election, that they have impunity to essentially violate state constitutional protections and do so without any kind of review by state courts. They have requested that the Supreme Court hear this issue in a petition for certification. We just last week opposed that petition to say this is a well-established matter of law that of course state courts can review legislation even if it impacts federal elections. That is the duty and obligation of state courts to do that. There is no issue for the court to decide. This is already very well established. And it's worth mentioning that the court's decisions have always assumed that state courts can go in and review these laws that the General Assembly passes that pertain to federal elections. And a good example is that Common Cause v. Rucho decision I talked about, where the Supreme Court essentially said the federal court might not be able to hear partisan gerrymandering cases, but state courts absolutely can. So we are still waiting on a decision from the Supreme Court as to whether they are going to hear this challenge. There are also appeals to the North Carolina Supreme Court on the remedial orders. Plaintiff Common Cause has appealed the state Senate and state House maps, saying that they are still not quite there as far as partisan fairness, but also that they require alteration in order to prevent vote dilution for voters of color. And notwithstanding these appeals, we know that for future redistricting cycles, partisan metrics and racial data analysis are going to be part of those processes. The legislature is going to have to present partisan metrics in order to ensure that the maps comport with the state constitutional requirements. And of course, they will have to do some analysis of racial data in order to assess what is needed to prevent vote dilution for voters of color. Also on the horizon are redistricting reforms, and especially the the reform of creating independent redistricting commissions in states. A number of states have enacted legislation that gives the power for redistricting to independent redistricting commissions. As we'll talk about, there's a lot of different models for this, but suffice it to say, the goal of independent redistricting commissions is to eliminate the inherent conflict of interest that legislatures have when they draw their own lines. There is an inherent conflict of interest when you have legislatures deciding their own districts. And to a point that the Reverend Dr. Copeland mentioned at the beginning of this presentation, competitiveness and the incidence of competitive districts is one thing that has decreased in recent years as the ability of map drawers to predict partisan outcomes has increased. In mathematical computing power in the last few decades has made it such that you can predict with very close precision electoral outcomes if you draw lines a certain way and for specific districts. And what we've seen is that where legislatures, even on a bipartisan basis, where legislatures are drawing districts, even when they're passing bipartisan plans, the effect of those is to reduce the number of competitive districts. So they do quid pro quo. Our party gets a safe district here and your party gets a safe district there. And it reduces the number of competitive districts. And you can see that in the current makeup of the House of Representatives. Across the United States, the number of competitive districts is in the dozens out of 400 plus seats. So independent redistricting commissions seek to be a reform that will help alleviate that inherent conflict of interest and allow for genuine competitive districts to be created where they make sense. There's a lot of different models for these. There's an independent, citizen-led. There's commissions that are made of politicians, and then there's commissions that are made of political appointees. Another difference in the models is that some commissions present advisory maps that are then voted on, versus some commissions create binding maps that the jurisdiction is bound to use. Unsurprisingly, the most effective examples are independent and binding. So independent commissions were used in California, Arizona, Colorado, and Michigan. And when I say independent, I'll use California's model as an example. They have a pool of applicants who put in an application to be part of the Independent Redistricting Commission. That pool is vetted by an administrative body. And then the only input that politicians really get is they get to take people out of that pool of applicants. And then the applicants are chosen by lottery, essentially. I'm abbreviating this process a little bit, but essentially that's an overview of how California's process works, and it actually worked with some success. Using politicians and political appointees, even, you just see the partisan dealings happen either directly or by proxy through the political appointees, and those are much less effective and run into a lot more issues. This is something that at least Plaintiff Common Cause has been advocating for decades in North Carolina, to have an independent redistricting commission that can redraw the lines every year in a way that honors genuine communities of interest, that ensures that neutral redistricting criteria is used, looking at county boundaries, looking at communities, and that the partisan dealings do not enter into the equation. So what are some next steps, and what can you do if you want to get involved in ensuring that we have fair maps in North Carolina? Well, there's redistricting advocacy. Notwithstanding that we are probably going to see redistricting for the congressional map at least come up in the next few years. Of course, this whole thing will happen again after the 2030 census. So There is ample opportunity to become involved in redistricting, but also general election advocacy and increasing access to the ballot for North Carolina residents, including our most vulnerable and historically disenfranchised communities, is very important to ensuring that we have elected officials that are responsive to our needs and that are held accountable. The 2022 elections, the primaries just occurred. At the county level, counties will be deciding their election budgets by June 30th. So you can get involved with your county about ensuring that there's adequate funding. There were recent efforts by the General Assembly last year to put in place restrictions on whether counties can get outside funding. For the 2020 election, at least, with COVID and all of the additional resources that were required to ensure that voting was safe, outside funding was crucial for a lot of counties, and being able to keep early voting sites open, staff those sites. So election funding, it's not the sexiest issue ever, but it's absolutely one of the most important when you're looking at ensuring free, fair, and safe elections in North Carolina. And then, of course, voting in the general election, where one-stop early voting begins on October 20th. And early voting is absolutely the best way to cast a ballot, especially if you have any questions or issues with your registration. If you do want to become involved, Southern Coalition for Social Justice has some trainings on the election funding advocacy. We also run an election protection hotline with our partners Common Cause and Democracy North Carolina. And if you have a legal background, we would welcome you to volunteer for that hotline. We also are doing advocacy tours across the North Carolina, different counties, and you can see if we're coming to your county soon. And then I just wanted to share a few resources from our partner organization, Democracy North Carolina. They have elections advocacy training. They recruit vote protectors, poll monitors at sites to report issues that might come up and assist voters. They also have trainings. And all of these resources and all these efforts are strictly nonpartisan. It's really about ensuring that every eligible voter in North Carolina has a genuine, fair, free, and safe opportunity to cast a ballot. And with that, I will be happy to take questions. I see the chat has been pretty active, so I'm happy to either go through that, or if someone wants to point out a few questions, that would be great to address.
Hillary, I've been writing down questions for you. So I'm going to start at the top. There was a question about people who are jailed or who are in prison. What access do they have to the polls? Do they vote where the jail is located, or do they vote where their home address is located? And maybe a follow-up question to that, do they even have the right to vote? And what can we do to help those for whom access to the polls is being denied?
That is a really wonderful question. And that is a question that is actually a little bit in flux with the some recent litigation. But I'll start with, can they vote and where do they vote? Absolutely, unless they are convicted of a felony, they can vote. So if they are convicted of a misdemeanor, if they are being held pretrial, they absolutely can vote. There are lots of barriers currently in place to them actually being able to realize that, but they vote where their permanent residence is. Even if they are temporarily displaced, they still vote back where their permanent residence would be in most instances, and they can vote by absentee ballot. That is the method by individuals vote, but it is by no means easy. And there are some great organizations. You Can Vote in North Carolina is one of them that does outreach to local facilities in which incarcerated individuals are housed. Now, I mentioned that it's in flux. There is a current litigation, CSI v. Moore. That is not a litigation in which we are counsel, so I'm not privy to absolutely all the details, but recently it is a challenge to North Carolina's felony disenfranchisement. And in recent decisions, the court has held that individuals who have completed their sentence and have completed their probation, notwithstanding any fees, that they can vote. But that decision has been a little bit in flux, and I think there was a reversal, and I would have to honestly look up the latest status of where that remained before the primary. But I can look that up quickly if people really, and put something in the chat if individuals, if anybody is interested.
Thank you. Another question that's probably still on your screen is the question from Keith about computer programs without bias. And I answered his question by saying, it seems to me if we can create a computer program that can generate such partisan maps, couldn't we use a computer program that presents us a map that is fair based on geography and community integrity? Maybe some of that work is being done by the independent councils that you mentioned, but if you could say more about how we can utilize these resources.
Absolutely. So so this is absolutely being done. The power of computing is being used for good, as it were, in generating maps that not only ensure partisan fairness and the opportunities for voters of color to have equal opportunity to elect candidates of choice, but also to allow for community input and other metrics to be put in and used to craft maps. So one of the plaintiff groups, North Carolina League of Conservation Voters, actually in the recent litigation, they had proposed their own map that was developed by political scientists in order to meet, as they had alleged, the set of fairness and other requirements under the North Carolina Constitution. That map was not adopted by the court, so that is not something that is like legally enforceable, but it certainly is something that people are proposing and using. And there are also there's also in computing ways to put specific parameters for maps and to generate hundreds or even thousands. They're called ensembles. And these ensembles are used to compare enacted maps for how likely they would be if you use just neutral redistricting criteria. So for example, the maps that were enacted by North Carolina in 2021 were compared against these ensembles of hundreds and thousands of maps, and were found to be 99.999% unlikely unless you were taking partisanship into account. And that's one of the findings on which the court based its finding that these were intentional partisan gerrymanders. It was not the blind squirrel that found the nut. These were intentional acts. But mathematical computing in redistricting can be used to gerrymander. It can be used to ensure fairness, for sure.
I'm not seeing any other questions in the chat, so friends, feel free to add your questions. But while we wait on that, I'm going to go back to something you said earlier. I don't remember the exact phrasing you used, but it had to do with if a policy issue in North Carolina swayed all the voters, let's say funding for public education. Everybody agreed that we should fund our schools at a higher level, that maybe even the level that the Leandro case presents to us. Even if we all agreed on that, what you're saying is a gerrymandered state is going to prevent that possibility from happening because we're not going to have legislators in place that will approve the policy issues that the voters say they want. So in other words, if we don't fix gerrymandering, nothing else matters.
Gerrymandering is at the absolute core. I mean, all voting rights voting rights issues are the absolute core of our democracy. It's a fundamental pillar of our democracy that the will of the voters decide the destiny and the future policy choices for those that are governed. And gerrymandering takes that away. And so with the maps that were enacted in 2021, what we saw is that one political party could get as much as 55% of the vote statewide and still remain in the minority. that it could get a majority, it could get 51% of the vote, but still the other political party would have a super majority, a veto-proof majority. And that's like fundamentally undemocratic. And the Supreme Court held, the North Carolina Supreme Court held, no, both parties have to have an equal opportunity to get a governing majority. And North Carolina, it's really important here because we have one of the largest groups and proportions of unaffiliated voters. And our, electorate is very sensitive to policy choices. We vote for for one governor of a party, and then we'll go the other way for senator and these statewide offices. So we are very sensitive to platform, but at least for these districted elections, under the maps that were enacted in 2021 and struck down, it wouldn't matter. It wouldn't matter if the electorate were swayed by a policy choice. The maps were gerrymandered in a way that they would just predetermine the results, unless you had a complete, 55, 60% voting for one party, which, as everybody knows, that just doesn't happen in our elections anymore.
I find that to be the most sobering thing you've said all day. That just really sets me back on my heels when I think about how hard we work at the council and all of our allies across the state on particular policy issues to help people understand them, to be aware of them, and then to find out that at the end of the day, because we're so gerrymandered, a lot of this hard work is really going to fall on deaf ears. But anyway, not to belabor that point, I do not have the power to unmute anybody, at least as far as I know, but Ron Katz would like to ask you a follow-up question about the jail populations and redistricting and how all of those things work.
Thanks, Reverend Copeland. Hillary, first, thank you for all that you do. Question I have is not so much about whether people in jail or in prison have the ability to vote, it's how they are counted for redistricting. I've heard that sometimes there are areas where there's a population of an extraordinary number of people that are in a prison, and they're counted in that area, but that's not where they live, but that is where they're sentenced to do their sentence. And I'm unclear how that is set up with the actual count for redistricting.
Yeah, I'm happy to answer that. So the issue that you've raised is one called prison gerrymandering. And so prison gerrymandering is just what you said. It's when you count individuals who are incarcerated, you count them in the census where they are incarcerated instead of where their permanent residence is. And the census currently does this. There's proposed legislation at the federal level to change the census. So it's counting people at their last legal residence, which is where they're most likely to return. So the census is good for 10 years, but people can be serving sentence for 1 year, 2 years, and then they're going to most likely return to where they were living before. So the change that needs to happen in the census is to count people where they used to live instead of where they happen to be incarcerated. We don't do that yet. So what happens is, and this is most impacting local jurisdictions, county levels, city levels. But what you're seeing is that at a county, for example, they'll have a large federal facility or statewide or regional facility. The biggest one in North Carolina is the Butner facility in Granville County. And in Granville County, they had always just kept counting the people incarcerated there, which used to include like Bernie Madoff. They used to count them as residents of Granville County. Now, Bernie Madoff did not have a constituent relationship with his county commissioner, I can guarantee you, but he was counted as part, like he doesn't care what the school system looks like or whether the roads are funded, right? And we at SESJ, we did a lot of advocacy, especially targeted at Granville, to say this time when you redistrict after 2020, take just exclude from the numbers the people in this federal facility. They are not genuine constituents. It was actually a 40% distortion. So 40% of the people in that one county commissioner's district in Granville County were just incarcerated people who were coming from out of state and going back after they're serving their sentences. And I'm pleased to report that after our advocacy, for the first time that we're aware of, Granville County, it did not prison gerrymander. They redistricted and they excluded the individuals there. But the real fix is to fix the census, because our incarceration rates are so disproportionate in who they impact in the communities. So people predominantly come from urban centers, and they're disproportionately people of color, and they're sent to rural areas that are predominantly white rural areas, is where a lot of the facilities are. And so what that represents is a huge distortion and overall a huge shift in power from one place to the other. So the real answer is that the census needs to be fixed just to reflect where people permanently live, and essentially count them the same way that they would vote. People generally vote, if they're able to vote, where they permanently live, and it's not a temporary displacement. It does not impact that. It's a great question.
We have two more great questions. One from Susannahuttle, who's going to unmute and ask her question, and then next Beverly Falls, whose question is in the chat for you.
Hi, Hillary. Thank you so much for this important conversation. In yesterday's event, we had a really incredible presentation from the Carter Center. And one of the major issues that we discussed was the role of dark money in elections. And I'm curious if through your work that you've been able to identify financial sources for North Carolina directing districting, and if there's a way to reveal those sources as part of our faithful truth telling with the North Carolina Council of Churches and our advocacy.
That's a great question. And the simple answer is no, because of legislative privilege. So our North Carolina legislatures enjoy something called legislative privilege, where they can shield all of that kind of information about who they're working with. And just to give you a little bit of context for that, the North Carolina redistricting litigation that we just had, we had to have our client group go through and look at videos of the redistricting to start to understand that there were partisan assistants essentially directing how these maps were drawn. They were not disclosed publicly. They were not named. There was no announcement that they would be used. And we had to do a lot of investigating to figure out who was drawing these maps, who was involved in the drawing of these maps. But a lot of that information is shielded by legislative privilege. So the short answer is no. Now, there are great groups. North Carolina Voters for Clean Elections is one group that really has done a lot of advocacy about dark money. So I would definitely check out their website. They've done a lot of advocacy on that. And also there are national groups like American Oversight that do a lot of document requests trying to follow the role of dark money. But unfortunately, at the state level, the legislative record related to redistricting is public, but there's a lot that can be shielded by legislative privilege from public view.
Hillary, did you see that question above? Let me see if I can get my screen back to it from Dr. Beverly Falls, talking about voter purging the rolls. She says increasingly concerned about voter purges that kick people who may have lived in one location for decades off of the voter roll, often without their knowledge.
This is another area that SCSJ we work in. We do a lot of data analysis and trying to track all of this work. It is definitely a concern in other states like Georgia. Voter roll purges have been a huge issue. It's something that we're continuing to investigate. But the process in North Carolina, as written, appears to follow, assuming it's the state board and county boards are doing what they say that they're doing. It appears to follow the requirements of the NVRA. They are often sued. Counties are often sued by groups coming from national groups, generally on the conservative side of the spectrum. They are frequently, about once or twice a year, sued in efforts to get them to purge their voter rolls. The state court does defend against those, and we often represent plaintiff groups that intervene in those to try to prevent any unlawful purges of voter rolls, but it's absolutely an ongoing issue. One of the, I would say that the state board has asked the legislature to fund ERIC, which is a group of states, 31 states, that share data when people move in and out of their states. And that has been shown to really improve the accuracy of voter rolls without sacrificing eligible voters getting knocked off. And it also, joining ERIC requires states to proactively seek out and find new voters and get them registered. So I generally, personally support North Carolina's joining of ERIC because I think it would help alleviate a lot of those issues.
Thank you. And Steve Ford would like you to look into your crystal ball and tell us if in your opinion, you think a flip in the state Supreme Court from Democrat to Republican is going to affect the conservative reading of the state constitution as it refers to voting rights. You could probably see that question in the chat.
Yeah, I will say this, that in the Supreme Court's decision on redistricting, there were 3 dissenters of all one political party. So I think that is one answer to that question. But I actually, because I frequently litigate in front of the North Carolina Supreme Court, I'm not going to go any further than that, but just point you that there is a 4-3, there is a 4-3 split on this decision. And the dissent written by Chief Justice Newby is publicly available on the court's website. So you can view that to see perhaps where there's those 3 dissenting, justices stand on a lot of these issues.
Okay, I think we have covered most of the questions in the chat. Thanks everybody for stimulating conversation, and thank you, Hillary, for giving us more information than we could have possibly hoped for on this matter, which, you and I talked before we came on live that it's not a sexy topic, but at the end of the day, this is the most crucial thing for getting ourselves into a legislative system that's fair and equitable for the people of North Carolina. And then, as we would say, as people of faith, allows everybody to flourish to the full extent of that individual's potential. And so we appreciate you framing this topic for us and helping us understand the nuances of what is really a very complicated process.
Well, it's my pleasure. Thank you so much for having me and for all of your work.
Thank you. And now I invite all of you who are still on the screen to join us in our closing litany, the litany that we use every day to remind ourselves of who we are and why we do this work. I'll say the parts in, well, I'll say all the parts actually, and you can mute yourselves and join me in the bolded parts. God of all the ages, who has seen every nation rise and many nations fall, endow in us the wisdom necessary to be a nation that rises to your call for justice and peace. God of all truth, who sees all eternity in the blink of an eye, bestow upon us the humility to listen to those who differ from us so that we might know your truth. God of all people, who has marked each of us as holy by creating each of us in your image, impart to us the courage to create a society where each of us can flourish to the fullness of our ability. Thank you for joining us. We'll be here again tomorrow, same time, same channel, and we will hear from Melissa Crum, who will talk about fair courts. And since so much of what Hillary told us today had to do with how the courts operate to keep redistricting an important feature in our state, I know you will want to hear what Melissa has to say about keeping our courts fair so that our laws can be fair. So thank you to everyone. We'll see you tomorrow.